All right, hi, welcome back, Attorney Steve Vonder, and welcome to another exciting episode of Litigation Whiteboard. All right, today we're talking about DMCA takedown process, and this is where you have a YouTube channel or you have an Instagram channel, TikTok channel, and somebody sends a letter to the platform and says, hey, somebody's using my copyrighted stuff, my videos, my photos, my music. Take it down. It's copyrighted. It's mine. They used it without authorization. How is that process done? Without further ado, let's head to the Attorney Steve Litigation Whiteboard. Okay, here we go. So this is what we call the DMCA takedown process, stands for Digital Millennium Copyright Act. This is the law that provides immunity to the platform providers, the service providers, the people you're familiar with, TikTok, YouTube, Twitter, any party that hosts third-party content, and they allow people to upload photos and images and comments and memes and all this other stuff. These companies get liability protection as long as they're taking down the copyright infringing material. Okay, that's maybe sometimes when you're uploading something to YouTube and somebody makes a claim or a strike against your channel and says you're using their video or you're using a piece of their music in your video. They don't like it, and so they want you to take it down. So here's the process. It's very simple. It's as easy as 1, 2, 3, take down, counter notice, and potential lawsuit if somebody wants to file one. So let's take a look. Takedown, there are certain things, as I mentioned, there's various types of content, photo, video, music, could be sound effects, could be aerial video, could be any type of copyrighted content. Okay, sometimes we see these in Etsy cases. Somebody says, you're infringing my jewelry. Your design is infringing my jewelry design. Take it down. So this is a takedown request. You go to the service provider. Look first to see if they have a form. If they have their own form, follow the form. And I will give you a link to a page that I put together that's got links to all the different major platforms. So you can send immediately a takedown notice. Who's making life easy for you? Attorney Steve, of course. So follow their form if they have it. If they don't, you can create your own DMCA takedown notice, submit it. You can find samples online. It's not too difficult. If you really need legal help, you know where to go. All right. If you can't find a DMC takedown, you can always go to the Copyright Office and look up the DMC agent directory. See who is their agent that will accept these takedowns. They have to appoint someone. If you want this kind of liability clearance and immunity, you need to have a designated agent. That's just part of the process. And the Copyright Office, I'll put a link to that so you can go find and search if you're in this situation. But really all you do is, before I put here, consider fair use before you issue a takedown. Why? Because if you don't consider fair use, somebody could say, that's a bad faith takedown. You didn't even consider fair use. I used 1 second of your video, 2 seconds of your video. That's not right for you just to file a takedown when you know it's fair use. So consider fair use before you do it. I have a checklist that I can make available, a checklist that would help you go through these things. Identify the work at issue. You make a little statement that you have a good faith belief that this is infringing, i.e. there's not a license, it's not in the public domain, that you do have the rights to it. You have the rights to the image. And you're declaring under penalty of perjury, POP, that the information you're providing is accurate. Okay, so that's how you submit the takedown. It's pretty simple. It's easy. Some sites are going to have their own little form you fill out. So you do what you need to do to get the takedown out there, okay? So that's step one. Simple, right? Now, this notice goes to, let's just use YouTube for an example. They say, take down, they've got my song in there, and the content ID system at YouTube didn't pick it up. They say, you got my song. And so YouTube will look at the counter note, will look at the takedown. They will send the counter notice to the other party, the party that uploaded the material, the third party that uploaded the material. And they'll say, hey, you got a takedown. Somebody's issued a strike. You can let the strike expire in 90 days. Well, that's no fun to wait around for that. And recently I've seen you can go to copyright school. Okay, I just had a case I'm going to post about in a minute. I had a company come in, Red Points, I'm going to do a whole separate thing on them. They came in and tried to say, you're infringing on my client's trademark in your video. And I was like, what are you talking about? This is ridiculous. Fair use, baby. So you know who won. Attorney Steve won that one. So you get the counter notice, okay? If you decide you want to do nothing, you just let the copyright strike expire after 3 months. Or you can issue a counter notification. This is where you're saying, that is crazy. I am not infringing. This must be a mistake or a misidentification. Those are the two key words. Mistake or misidentification. They chose the wrong video. What are you talking about? They got the totally wrong video here. The one they identified is not the right video. This is a joke. Counter notification, okay? Or a mistake could be things like this. You have a fair use, as we talked about. It's a 4-factor test. I have lots of videos out there on fair use. I'll put a couple down in the description area so you can take a look at it. Fair use. Or you have a license. This happens to me sometimes. I use a site called Storyblocks, and they have video and audio sound effects, and I will use those in my videos. Well, I have a license to use the platform, and every so often some company will come and try to either monetize my video, hop on top of that and do all that, or they'll try to issue a strike and a takedown and all that. And I say, what are you talking about? Attorney Steve's a copyright lawyer. I mean, come on. I have a license for this. Take this thing down immediately, okay? I haven't lost one of these yet, by the way. Fair use, you have a license, or the could be something that's in the public domain. This image is 150 years old. It's in the public domain. It's a picture of the Mona Lisa, for God's sakes. It's in the public domain. You can't tell me to take that down. This could be another grounds for a mistake, a good grounds to file a counter notification. And finally, you could just say, what are you talking about? This is my independent content. I independently created this. I have no knowledge of what you are doing, and it just so happens to be similar, but it's a picture of a flower. How many different ways can you draw a flower? I drew a flower. It's mine. So these are some of the grounds that will help support a good faith grounds that you have a counter notification. YouTube, for example, will look that over and they will decide if they feel like, okay, there is good faith grounds. They will then take the video and put it back up. So if you follow my arrows here, it's very simple. You send the takedown, the image or the photo or the song comes down. You file the counter notification. YouTube says, yeah, that's good. It goes back up. Now, they may decide, I'm not going to send it over. This makes no sense what you're talking about. You used 30 minutes of a 30-minute video. There's no fair use. We're taking it down. It's got music. It's a total disaster. You must not be watching Attorney Steve videos. And in that case, it will just go down the way. You'll get your strike, and you can either do your strike or go to the copyright school to get it removed. But you don't want those strikes. 3 strikes, they could take your channel down. It gets ugly. I've seen Instagram accounts taken down, TikTok accounts taken down, Instagram accounts taken down. So it's not fun. But if you file the counter notification, goes back to the other party, content goes back up. The other party has 10 days. I have it right here, 10 days to either file a federal court copyright infringement lawsuit or do nothing. If they do nothing, the image is back up. You win. If, on the other hand, because remember one thing that you're doing here, when you're filing this counter notification, this is very critical. If you're an out-of-country defendant, you need to be careful because in submitting this counter notification, you will be admitting to personal jurisdiction where YouTube is located, for example, in San Bruno, California, and you could find yourself in the Northern District of California fighting a copyright infringement case, even though you're from Italy. How fun is that? Or France, right? So here you are. So be careful. You are consenting to personal jurisdiction, and under penalty of perjury, same thing here. You're saying you have a good faith belief that this is a mistake or misidentification. Now, if you're screwing around with the rules, you're doing things in bad faith, there is a claim called 512F, and that is a bad faith takedown process, either the takedown notice or the counter notification in bad faith. It's tough to win on. You have to prove subjective bad faith, that subjectively they had bad faith. It can be difficult to prove. Now, if this other party says, well, I'm going to file a lawsuit, the content comes back down. So here, follow the arrows. Takedown, image comes down. Counter notice, Google says, yeah, it's good to me, goes back up, lawsuit within 10 days, content comes back down. How simple is that? 1, 2, 3, the DMCA takedown process. Now, last point, I just want to talk about what gets filed in these copyright infringement lawsuits. It's usually just basically a claim for copyright infringement. You had my material, you copied it, you publicly displayed, distributed it through YouTube without my permission. That's copyright infringement. I want damages. Now, their copyright has to be registered in order to bring this claim. That's a requirement in federal court. You must have a registered copyright. But another claim that we see often is what we call the 1202 claims. Got that right there, the 1202 claims. That's when you are falsifying or stripping CMI, copyright management information, and you're basically taking off their copyrights or their authorship information and kind of pretending that it's your own in order to conceal copyright infringement, okay? And then finally, you will also see this many times, the 512F, saying they brought that counter notification in bad faith. So anyway, the parties can fight about this. They can countersue each other over the 512F claim, so forth and so on. But that's really what you're looking at. I would just say be careful and think twice when you're filing these claims and counter notifications. It is a good time to get legal counsel involved. You don't want to be doing things that you cannot later retract. Okay, you're putting little comments and things into your takedown notice or your counter notification. You're writing everything about your test. You want to be specific in these counter notifications as well. You want to make sure that they are going to take your counter notification serious and pass it on to the party that's issuing the takedown. So you might want to seek legal counsel before you dig yourself into a hole that you can't get out of. So this is general legal information only about the DMCA takedown process. This happens on so many different platforms. Etsy, people selling designs that are copyrighted, or it could be a trademark dispute somebody's doing it on. But I just wanted you guys to know this. I realized after all this time, I didn't have a good video on DMCA takedown, so I said I got to get one up. So hey, everybody, happy Valentine's Day. I hope you guys treat your significant other with love and the greatest day of their lives. Have fun. I know I'm going to do that tonight. Thanks for watching. Feel free to share this video right here. Don't forget to punch that like button and subscribe. This is general legal information only and not legal advice. We'll see you next time. Thanks for watching.